Okay, we'll go ahead and get started. Good evening, everybody. I'm Mike Cromer, President of the Hillsborough County Medical Association. Thank you for joining us tonight for the retirement planning webinar. Um, Tonight, we'll be joined by a good group of panelists, including Michael Jensen and Jeff Anderson from Jensen Anderson Wealth Management, a financial planning company that has been serving as an HCMA benefit provider since January of 2020. And this is actually the second seminar that we've held during this COVID time on retirement planning. And we have a good group tonight, and we'll look forward to getting started. Both Mike and Jeff have been working in this field for many, many years, and they're dedicated to serving physicians. So I'm interested in seeing what they have in store for us tonight. We'll have some other panelists join us, and they'll be introducing them at that time. For those of you who may or may not be new to Zoom, there is a icon at the bottom of the screen that says chat. If there's press on that to open up a chat box. And if there's some questions that you would like to ask during this seminar, please feel free to write them in and I'll be monitoring that for questions. Mike and Jeff have sort of a casual type of presentation, a conversational type of approach, and they welcome questions as they come up. So please don't hesitate to bring up your questions while you're thinking of it, and they'll do their best to answer the questions. So with that in mind, thank you for joining us again. And Mike and Jeff, I'll turn it over to you at this time.
Thank you very much, Dr. Cromer. And also thank you for bringing up the point that when Jeff and I give conferences or teach classes, our main technique is we use a conversational method. We will talk back and forth to each other, Jeff and I, and he will ask me questions and I will ask him questions, and we will ask questions if we think that someone out in the audience should be asking us. My background is CFP and all these other letters behind my name. I've been on the faculty at Mersani, well, USF College of Medicine's Mersani now, for about over 25 years. So I may not know much, but I know physicians. And Jeff is probably the guy with the brains in the outfit, but we're here to help you any possible way that we can. There's nothing that we haven't heard. So we ask you to ask questions because that's how learning is achieved, by asking questions. So with that, Jeff?
Yeah, I'd just like to give a couple, some piece of information as far as housekeeping. We sent you out books prior to the class. That book's a great resource. A lot of the slides they go by the book, but we cut out a lot of the slides. So if you're following along with the book, there's some of the slides that we cut out. So don't be concerned. If you look in the top right, you'll see the page number of each slide. We also sent you out a folder. There's some handouts inside there as well, but we'll let you know. And if we're using a handout, we'll put it up on the screen for you. So the first chapter we're going to cover is life planning for retirement, which we call lifestyle goal setting and things like that. So Mike, you're up.
Yes, times have changed. Your parents very likely worked at one place for a long time. So they'd work there and they'd have some type of retirement plan, they'd have Social Security, and then they'd retire at 65. And they didn't really do planning for lifestyle because they were probably dead by 75. I don't mean that to be disrespectful, but it's different. That's the traditional view. Today is much, much different and a modern way to look at retirement.
Yeah, people are living a lot longer now. So lifestyle planning, now you're planning for 30, 40 years sometimes in retirement versus in the traditional model, maybe only 5, 10, 15 years. So some questions to consider. What will be my primary source of income during retirement? Where am I going to generate income from? Am I going to work post-retirement? And will my partner? Mike, you might want to comment on that one because we know physicians take a while to retire.
One thing with physicians, and I know I told this to the last group that I did these for in the fall. I said, I literally quoted 3 clients of mine within the last month. And one was about 35, 37. He was just starting. He had just signed a nice contract with one of the larger groups. And we said, well, when will you want to retire? Oh, 45. That's it. 45. That's it. I'm going to retire at 45. Then I had a physician at age 55, 52, 55 in there. And I was asking him, well, when are you going to retire? He says, I don't know, Mike. I think maybe, 57, 65, something like that. And then I had one that was 75 years old. Okay. He's still practicing. He doesn't scrub anymore. And he was worried about retiring. And believe me, all three of the people the physicians I just said, financially were no problems. He was worried about a mistake that we see happen, not a mistake, a problem that we see happen with physicians. Because whether you like it or not, you become identified as a doctor, and they don't know what to do if I stop. So the ones that were going to stop at 45 or 55 or 65, when they really do have to face it, they're slow, very slow going out. They think they've died and gone to heaven, when they're not working weekends and they're not on call, but they'll still work as many hours. So physicians are different animals. They sort of fade their way out. They have the independence to do so.
Yeah, we see that they truly love what they do, and they want to continue to do it as long as they can. So what age do I want to retire? Does my partner know this? One thing we do see with a lot of physicians is that the spouse who isn't a physician, we want them to retire, and they want to keep working. And so it's important to make sure you're on the same page and open up the dialogue and have those conversations. And the other one that we see too is if in a couple situation, one of them usually leads in the financial management part. Well, what happens if that person passes away? Is the other person okay with handling that? So that's the last bullet point here. Who should my partner speak to about financial advice if I'm incapacitated? And that's something you need to think about as well.
And we're going to mention the exercise, the partner exercise. Please do that. You have to be on the same page with your partner or spouse or whatever. But when you are retiring, that's not the time to start discussing this. You need to discuss it now. Go ahead.
Yeah. So inside chapter 1 in your book, there's an exercise. And this helps try to paint the picture of what your retirement's going to look like, which is your lifestyle goals. What do I want to achieve in retirement? So this is a great exercise to go through with your spouse or partner to make sure you're on the same page. So do it individually and then compare and this is going to open up the dialogue to make sure that you're both seeing eye to eye. You both understand what's important to each other in retirement. And that's going to make things a lot easier going forward. And getting everyone on the same page is not a bad thing.
Yes, please listen to Jeff and do that, please. Yep.
And that's what lifestyle planning is all about. Lifestyle planning is not something that a financial planner can tell you. This is something that you really have to look through the lens of when you're retired and what's that going to look like. Maybe I'm going to retire at age 70. I want to go and travel and see the grandkids 3 or 4 times a year. I want to travel to Europe once a year. Where do I want to live? Do I want to still stay in Florida? Do I want to go somewhere else? Those are all the things that you're going to start to talk about and think about and discuss with your partner or spouse. So what's the new retirement planning process look like?
Yeah, today, because the largest growing age group are people over 100, and people aren't retiring at 65 the way that they used to. Today, you have to plan more. There's certain things that you had to do. You had to determine the outcome that you want to achieve. What do you want? By the way, you have to educate yourself to make informed decisions. Jeff, I don't think we have to say that to anybody in the class tonight, because that's what you're doing right now.
I mean, you're approaching retirement, and you're in the retirement red zone here for a lot of the people on this class. So you understand the importance of education, and you understand the importance of you're going to be faced with a lot of decisions as you approach retirement and that you have to make in retirement. So you want to make sure that you execute those decisions coming from a place of knowledge and making sure you don't go down the wrong road, because you can derail your retirement with some bad choices. So you want to make sure you're educated and you're well-versed to make those decisions.
Yes, the people on this call, the physicians on this call, I don't want to make a covering statement, but they're all going to be okay financially. most probably. The real thing that they have to plan for is, what do I do? These things that we're talking about right now, because it sneaks up on you. So that's more important. You'll be okay financially, most probably.
Number three is really kind of the next step in developing your retirement plan or financial plan, which is my net worth statement and my cash flow statement. Where am I now? What assets and liabilities do I have? And then cash flow. How much money am I spending and how much money is coming in? We're going to talk more about that in chapter 3. Mike, you want to cover number 4?
Yes, I think, and I'll probably say the most important thing, I'll probably say that 5 or 10 times a night, but probably one of the most important things, if not the most important thing, is that you have to develop a financial plan. It's like the old line: if you don't have a map, you're not going to be able to get to the destination that you want. You need to do a financial plan, okay? And you need to do it with a professional. And the thing is, you have to review it every year. Go, review it. And with that, it gives you step-by-step ways to achieve your financial goals, but also your personal living style goals.
Yeah. Number 5 is the implementation of the plan. Just because you did the plan, you're not all done there. There's a lot of times that you may need to realign your portfolio. Maybe you need some disability insurance, maybe you need some life insurance, some long-term care, all these things like that, and that you'd actually need to put those things in place. And then the last one, Mike, you kind of touched on it earlier, reviewing the plan. We know that that's one of the most important things to do. And you should do that on an annual basis at a minimum.
Yes, because people change. And sometimes you don't do it. Like, one of the things you'll hear us say all the time is, oh, when's the last time you read your wills and trust? People say, I don't have to read them. Yes, you do, because you change over time. But reviewing the plan is paramount. Go ahead, Jeff.
Yep. So we wanted just to do the intro of chapter 1. We're going to do the estate planning part next. Mike's going to do the intro for Bill McQueen. We are going to shift gears here, and Bill is going to share.
Is Bill with us right now?
Yes. Yeah, if you want to do the intro, and Bill, if you want to share screen. Okay.
All right. We want to thank the people that come and speak to our physicians like this. Bill McQueen is an attorney. He's an excellent attorney. He's also a CPA. Okay. He practices as a physician, but he has a lot of experience. You're going to hear the same thing about Jason probably, but they have a lot of experience with physicians, because you're different animals in many ways. And there's 2 or 3 really, really good law firms here in Tampa that, we could refer you to them all, but Bill's used to this. So ask him any question that you have also, because he's been down this path before with physicians. So it is my pleasure to introduce Bill and respect Mr. McQueen.
Thank you, Mike.
Bill, you're not in presentation mode.
Okay. Am I now?
Yes.
There you go.
Right. There you go.
Thanks. That was a little technology, Jeff. Well, good evening, everyone. I get the pleasure of spending the next 25 to 30 minutes talking to you about estate planning and the importance of wills and trust. So we've got a lot of information to cover, and so I'm going to have to go fairly quickly and at a relatively high level. But as Mike mentioned, feel free to put questions in the chat box. I'm happy to answer them at the end. My contact information will be provided at the end. I'm happy to take emails or phone calls or meet with you in person if that would be helpful for you, all on a complimentary basis. When it comes to estate planning, a lot of people think, well, the only people that need to worry about estate planning are old people, or people that are nearing the end of their lifespan, or the very wealthy. But that's really not the case, because the whole goal of estate planning is to achieve 2 principal objectives. One, for you to have input and decide where you want your wealth to go and in what manner upon your death. And 2, in the event you become incapacitated before your death, you get to choose the people that will be making legal, financial, and healthcare decisions for you. We don't know when either one of those 2 events may happen. And so it's never too early to start planning for your estate. And so whether you're working, retired, single, married, wealthy or not, you ought to have an estate plan that's in place. A lot of people think, well, estate planning has to do with taxes, death taxes, or estate taxes. There used to be a lot more focus on that when it came to estate planning. But the good news, at least at the moment, from a federal, well, if you're a Florida resident, all we have to worry about are the federal estate death gift taxes, transfer taxes. And at the moment, we're at an all-time high watermark of the amount of wealth someone can pass at their death before federal estate taxes kick in. Someone who were to die right now, the beginning of 2021, they could give away up to $11.7 million worth of wealth. And so if they're married, they could actually give away over $23 million of wealth before the state taxes kick in. And estate taxes can be rather punitive. The rate right now is 40%. But most people, less than 1/10% of the US population has to worry about estate taxes now, or death taxes from a federal standpoint. And so where we really spend more of our time is focusing on income tax planning, really, when it comes to estate planning now. So that's all we're really going to talk about when it comes to estate tax planning as far as this evening is concerned. I'm going to sort of go sequentially and first talk about the aspect of estate planning from planning for your incapacity. We want to make sure that you have certain documents in place that we refer to as advance directives. There's 5 that we want our clients to have to make sure that if you did become incapacitated before your death, and the odds now is anybody who's alive today and over the age of 60, you have a 70% chance you will become incapacitated at some point in time prior to your death. If you don't put in place certain instruments or make decisions now, basically the court will make those decisions for you. And so it's very easy to have 5 of these advance directives that will handle the issue of incapacity. The 2 main ones are a durable power of attorney and a healthcare surrogate. The durable power of attorney is where you name somebody to make legal and financial decisions for you. Typically, if you're married, people usually name their spouse as the primary agent underneath this durable power of attorney. But we always want to name at least 1 or more alternates in case that primary person can't serve when the need arises. Often that may be children. The healthcare surrogate is like a durable power of attorney for your medical reasons, medical needs. This is the person that's going to make those medical decisions for you if you can't do that on your own behalf. Again, married couples usually name their spouse as the primary person. And oftentimes, I'd say probably about 80% of the time, the same people in the same order that they name under the durable power of attorney, they name underneath the healthcare surrogate. Talking to physicians, I'm sure you're very familiar with HIPAA. A HIPAA waiver is just your ability today to say, these are the people that if in the future I'm incapacitated, I'm okay with my medical professionals sharing my medical information with these people. They don't get to make the medical decisions for the incapacitated person. That would be the healthcare surrogate. But this allows family members, especially children, to be able to talk to the physicians, understand what's going on, hear it directly from the doctor themselves. The living will is the advance directive that deals with that limited situation where somebody's incapacitated and now their medical professionals have determined primarily they have some form of terminal illness where their death is imminent, but their life can be prolonged through certain mechanical means, ventilator, respirator, feeding tubes. This is the ability for them to state their wishes, whether they would or would not want to have those procedures applied in the event those circumstances arise. And then the last advance directive, the declaration of pre-need guardian, is one that many people haven't heard of. What people don't realize is that a third party can bring a guardianship proceeding against you, somebody that doesn't even have anything to do with you whatsoever. But if you sign a declaration of pre-need guardian today, then the court has to honor that, and whoever you name in there as your requested guardian is the only people that the court can appoint. Because what will happen if somebody brings a guardianship proceeding, what I call an involuntary guardianship proceeding, and the court finds you to be legally incapacitated, that voids out your durable power of attorney and your healthcare surrogate, because the appointed guardian will now have the authority to make those decisions. What we have clients do is sign a pre-need guardian declaration where they name the exact same people they name underneath their durable power of attorney and healthcare surrogate to serve as their guardian. And the reason we have clients do that is it pretty much guarantees that nobody will bring an involuntary guardianship proceeding, because the only reason they want to do that is they want to get appointed as your guardian, get control of your assets and your person. And it's just not going to happen because the judge does not have the ability to name them as your guardian. They have to name who you named in this document right here, which would be the same people you have named underneath your durable power of attorney and your healthcare surrogate. I'm now going to shift and talk about the aspects of estate planning when it comes to passing your wealth at the time of your death. And the way the law determines who's going to get your wealth at the time of your death really depends upon how you have titled your assets while you're alive. Assets can pass in one of 3 ways upon your death. They can pass by operation of law. And that's where people own assets as co-owners jointly with someone else with rights of survivorship. If you are married, you and your spouse own property in joint name, be that a bank account or a real estate. That's a special type of joint ownership known as tenants by the entireties, and it presumes that there's rights of survivorship. If you own property jointly with somebody else, a sibling or a child, you need to spell out in particular, if you want them to get that asset upon your death, that you're owning that as joint tenants with rights of survivorship. Otherwise, it's presumed it's tenants in common, which mean you each own an undivided 50% interest. And when you die, your 50% does not go to the other co-owner. Any property that passes by operational law, just automatically when the first co-owner dies, the surviving co-owner just has to take a death certificate to the bank or record it among the public records, and now they own 100% of that asset. Very simple, very easy to do things. The next way assets pass are by contract law. Those are primarily assets where you name a beneficiary to receive the asset upon you, the owner's death. Prime examples of that would be life insurance or IRAs, retirement accounts. You as the owner of the 401k or the participant, you die, you've designated your spouse or your children as the beneficiaries. All they have to do is give a death certificate to the custodian of the IRA or the trustee of the 401k, and now that account becomes theirs. The last way property passes is any assets that you own in your individual name when you die. And what comes into play there is whether or not you've invoked your privilege to draft a will to say where you want those individually assets to go. If you don't have a will when you die, Florida law gives you a will. It's what we call intestacy provisions. And basically the Florida legislature says, this is where the average person would want their wealth to go. And it all depends upon who you're survived by, whether you're survived by a spouse, children, or the children of this marriage. All those types of factors come into play to say who gets it. However, if you invoke your privilege of doing a will, then you can say where you want those assets to go. And that's what will happen in most all instances other than one that we'll talk about. Who should inherit your assets at your death? The good news is under Florida law and the law of really all the states within the United States, you can leave your assets and your wealth to whoever you want. Unlike certain other countries, especially in Europe, where they have what's called forced heirship, where if you have children, your children are automatically entitled to a certain percentage of your estate. That's not the case here in the United States. You can disinherit children if you want. The only person who you cannot totally disinherit would be a spouse. If you're legally married at the time of your death, your spouse is entitled to what's called the spousal elective share, which is 30% of the wealth the deceased spouse owned at the time of his or her death. And we'll talk a little bit more about that as well as we move through the presentation. How should people inherit your assets? Well, we look at a lot of factors when we're laying out an estate plan with our clients. You know, what's the age of your beneficiaries? Are they adults, but are they financially mature enough yet to handle the wealth they might inherit? Do some beneficiaries have more financial needs than others? Do they have special needs? Do they have creditor problems? Are they going through a divorce? Are there certain tax implications? So we take that all into respect when we design an estate plan that and put provisions into somebody's will or trust, as we'll talk about. The easiest way to leave assets upon your death are just outright bequest. So, you know, in my instance, I'm married and have 3 daughters. You know, my will might just say that upon my death, if I'm survived by my spouse, I leave everything to my wife outright. If she doesn't survive me, I leave everything outright to my 3 daughters. But, you know, the simplicity is not obviously always the most effective way to leave assets. And most people nowadays that have any wealth at all, which would be most of my physician clients, will leave their wealth to the next generation and even to the spouse, usually within a trust type mechanism. And these are the types of factors that we look at to see whether or not it might make sense to have a trust in a play. And we'll talk about that a little bit more as we go along. With a will, I mentioned a will dictates where your assets go that are in your individual name, and a will has no legal significance until the time of your death. The other thing you need to keep in mind with a will, you may have a will that says, hey, I leave all my assets to my 3 children in equal shares, but most all of my wealth is held in a 401k or retirement plan. And for whatever reason, I said, I'm going to leave all my retirement assets to just my 1 child with the idea that he or she will divide that up amongst the other siblings after I'm gone. Legally, all of my wealth will go to just that 1 child. And if the child decides they don't want to share it with their siblings, it doesn't matter what my will says. The will doesn't control that asset that passes by contract laws we were talking about earlier. So you want to make sure that the way your titles, that if your will is going to dictate where your assets go when you die, you want to make sure your assets are titled in your individual name or in an appropriate fashion to pass under your will. What happens when somebody dies and we're using a will? The way we get the assets out of their individual name over to their designated beneficiaries, we have to go through the court system. And it's a process known as the probate process. And it's really sort of a retitling process after somebody's died. It's there for the benefit of the person who died. They're not there anymore to tell us that, yes, this is definitely where I want my wealth to go. And so the court reviews the will, makes sure it's valid, notifies interested parties. Somebody gets appointed the power, which many states call the executor, to administer the estate. Here in Florida, we call that personal representative. They have to inventory all the assets, publish notice so creditors can come forward and file claims, pay the creditors' claims, make sure all the tax returns are filed, and ultimately they distribute the assets onto the named beneficiaries. Most clients, again, that have any wealth of any real nature, which I would say anybody that has more than $300,000 to $500,000 of wealth or more, usually wants to try to avoid the probate process, primarily because it is court supervised, which means you have to have lawyers involved in the situation. And so there's going to be attorney's fees, and there's going to be fees paid to the personal representative and other court costs. And many people say, well, you know, that gets more expensive than what I think it ought to be. Under Florida law, basically what's presumed to be a reasonable attorney's fee for representing an estate is 3% of the value of the estate going through the probate process. Also built into the court system in the probate process are certain time periods that the estate has to be held open. And so it's not uncommon when we have a full formal probate administration, somebody dies, the estate's not going to be closed out for 12 to 18 months after the date of the person's death. And that can often be longer than what people would like to have it last. And last, most people think their will is a private document. You know, that's all about your wealth and where it goes after your death. Why should anybody else have the right to know about that information? And that is the case up until the time of your death. When you die, your will by law has to be deposited at the court in the county where you were residing at the time of your death. And it's now a public document. Anybody can go read your will. And so that's why in particular, you'll see a celebrity die, especially in New York State, where they still use wills more than trust. And then you'll read in the newspaper where they left their estate to, or who they included in their estate or who they didn't. And it's because the reporters went down and read their will and then wrote a story about it. So if somebody wants to avoid probate for any one of those reasons or all of them, how do we do it? The way most people do it is they use a will substitute document. It's referred to as a living trust or a revocable trust, or some people even call it a revocable living trust. Basically, we create this trust and we put all the same terms that we put into your will into this trust document as to where you want your property to go after your death and in what manner. The reason why we use this trust, though, is unlike the will, the trust has legal significance when you create it. You could view it or analogize it to creating a corporation. It's not an entity, but that's the easiest way to look at it. And so what can happen is we retitle the assets out of your individual or joint name while you're alive, where we don't have to have the court system involved in the process and the added expense and delay. And we put it into this trust. And so when you die, the trust is still alive and the trust legally owns those assets. But the trust now says, rather than holding those assets for my benefit, if it's my living trust, now here's what's going to happen to the assets. We're going to divide them up in equal shares and distribute them out to Bill's 3 daughters. Keep in mind that even if you're going to do a trust-based plan, you're still going to need to have a will, a last will and testament. We lawyers refer to that type of will as a pour-over will. And what that is, it just serves as a backstop so that if upon your death you do have any assets that are in your individual name, this will says those assets pour over into this trust, and then the trustee will distribute those assets out to where they go. If you didn't have that pour over will and you died with assets in your individual name, then we're back to that issue of intestacy, and we're going to look to Florida law as to where those assets that were in your individual name is going to end up going. And in all likelihood, it will not agree with what are the terms of your trust. So the way the living trust works, we create it, and then we fund it. We retitle assets out of your individual or joint name, be that real estate, bank accounts, investment accounts, things of that nature, into the name of the trust. I mentioned already what the pour over will does. Usually the person who creates the trust, if it's my living trust, I usually serve as the trustee of that trust while I'm alive and have capacity. You can view the role of trustee like the role of the president of the corporation. So the trustee is the one that has legal title to the assets in the trust and follows the terms of the trust, but dictates where those assets go. While I'm alive with a revocable trust, I can change the terms of that trust whenever I want. I can put assets into it, take assets out. I can use the assets for anything I want to use them for, no differently than if they were in my individual name while I'm alive. And I can even revoke the trust. Because I have so much power over this trust, for income tax purposes, this trust is what we refer to as a grantor trust, meaning that we're going to disregard it basically for income tax purposes. So we don't get a separate taxpayer identification number for the trust. We don't file a separate income tax return. Any taxable income earned by the assets in this trust just go right on my individual 1040 every year. So once the trust is set up and funded, your day-to-day operations with the trust is really no different than it is if you had the assets owned in your individual name. The benefits we get, though, is unlike with a will, your trust never gets deposited with the court and should never be recorded among the public records. So if somebody's interested in where Bill is leaving his wealth after his death, they can't go down to the courthouse and read my trust document there. It remains private. Built into the probate process is a procedure for people to contest your will. So it's very easy to decide to contest somebody's will. It's more difficult to contest an estate plan based on a trust because an independent civil action has to be instituted if you want to do that. After somebody dies, if assets are in the trust and they remain in a trust on a continuing basis for the benefit of your spouse and or children or others, that can provide asset protection to them from creditors or future divorces. And lastly, hopefully some of you either already or in the future might be planning, and Jeff mentioned earlier on, maybe after you retire, you might want to move away from Florida, or maybe you want to keep Florida as your primary residence, but you're going to buy one or more vacation homes in different states around the United States. If you're using a will as your main document for estate planning purposes, and you're holding these assets in your individual name, then upon your death, not only are we going to have a primary probate administration here in the state of Florida, we're going to have to do additional probate administrations, what are referred to as ancillary probate administrations in each state where you own real estate, because every state is very protective of their real estate. And even though there's a probate taking place down here in Florida where your primary resident is, North Carolina or California or wherever you've got this other property, they're going to require you to do another probate administration there as well. So additional expense, additional attorneys. Instead, if you have a trust, you can title those additional homes, vacation homes, in the name of your trust, and you can avoid probate altogether. I've been talking tonight about revocable trust, which again are primarily used for probate avoidance purposes. Again, a revocable trust, you can change it and you can revoke it at any time. It provides you, the physician, while you're alive, no asset protection. And also any assets in that trust will be included in your estate when we look to see if you owe estate taxes when you die. There are times, though, with more advanced estate planning where we might use irrevocable trust, where you create a trust that technically is permanent and you can't change the terms of it, and you move assets into it either as a completed gift or an incomplete gift and give up certain amount of control over those assets. We might do that for all sorts of reasons: asset protection planning, for getting assets out of your estate for estate tax planning purposes. Maybe you have parents that are getting close to having to go into a nursing home or something, and so you want to get them qualified for Medicaid earlier in the process. You might set up an irrevocable trust known as a Medicaid asset protection trust for that. So those are all types of things where we use an irrevocable trust, but I just wanted you to be clear that there is a difference between a revocable trust and an irrevocable trust. Who should draft your will or trust when you're doing your estate plan? Well, this is a shameless plug for attorney employment, but you really should use an attorney. You can find wills and trust documents online or form books all over the place, and you should probably use one that specializes in this area. You're not going to know whether or not you pulled the right form out of the book or answered the questions correctly until you're gone, and it's too late then to go back and change things. And I cite to a case here from our Florida Supreme Court, the highest court in our state, where just very recently, within the last 6 years or so, a lady used a form type will. The court said it was very clear from the evidence that this is not what she wanted to have happen, but this was what was in her will, and so they had to follow the terms of her will. So people within her family, other than who she wanted to get her assets, ended up with her assets. One of the major decisions you're going to have to make when you're doing a will or a trust is who's going to be in charge of your estate after your death. That's your personal representative if you're using a will, or a trustee if you're using a trust. It mainly comes down to, do I pick a professional, or do I use, typically or oftentimes, a family member? This lists out some of the pros and cons of those two selections. And as I share with clients, if they're really struggling with which way to go, you can obviously also do what I call the King Solomon approach, where you have co-personal representatives or co-trustees, one who could be a professional, one who could be a family member. So you sort of get the best of both worlds. There is a lot of responsibility that comes with being a trustee or a personal representative. As professionals, as physicians, it's probably, if not already, sometime during your life, somebody that's a good friend or a family member may very well ask you to serve in one of these roles. And it definitely is an honor, but you need to just go into it with your eyes wide open. There are a lot of things you need to do, and you need to keep in mind that if you don't do what you're supposed to do, and maybe you make distributions too soon and there's creditors that should have been paid and they don't get paid, including the IRS or other things of that nature, you personally are responsible for any shortfalls if you can't get the money back from the people you distributed it to. So just want to make sure, again, that you go into that process with your eyes wide open. Another thing that goes into your will is if you have minor children or grandchildren that you're responsible for, this is where you would name a guardian to look after those children until they reach majority age. And very, very important decision to make. Here are some of the things that you might want to be looking at as you decide who you're going to select for that role. The sentimental stuff. Under Florida law, if your will includes what we call a separate writing provision, you have the ability just to make out a list and say where you want your tangible personal property to go. And a tangible personal property are things like jewelry, furniture, artwork, your gun collection, your car, a boat. What it's not is cash, real estate, investments, things of that nature. But what this allows you to do is today say, well, here, I want to leave these things to these certain people. And then 5 years from now, you've accumulated more sentimental things, and you can make out another list and say, I want to leave these things to these people now. That list does not have to be witnessed. It doesn't need to be notarized. The lawyer doesn't need to be involved at all. So it gives you flexibility to make changes about these things that often are very important to the family, though they may not have a lot of monetary value with it. And I strongly encourage clients, if they do have any specific desires as to where they want these types of things to go, that they should do a separate writing. Because in my personal and professional experience, I've seen where often the tension among the family members after their parents have died more deals with these sentimental things than the cash money. And so if mom or grandma really wants certain children or grandchildren to get certain things, it's well worth putting that in writing in the form of a separate writing. I'm sure Mike and Jeff are going to talk with you a lot about life insurance and the important role it plays in estate planning, and it does. Primarily, a lot of times, from my perspective, from a liquidity standpoint, to make sure there's money there for continuing support or to pay taxes or things of that nature. And they will go over with you more specifics on life insurance as the session continues. I'm going to conclude my brief time with you with a couple of case studies that try to pull some of this together to sort of paint a better picture of what can happen. Blended families. I would say easily 60% of the clients I have nowadays that come to me that are married is a blended family, where one or both has been either divorced or widowed. They have children from an earlier marriage or relationship. They're happily married now. And usually they come in and their desires are that, we don't know who's going to die first. I want to make sure my spouse, if I'm the first one to go, is well taken care of for the rest of his or her life, even if that uses up all of our wealth. And then after that, we want the assets divided among both of our children in some fashion, whether it's equally or possibly unequally if maybe one of the spouses has more wealth than the other one. When we don't have a blended family situation and all the children are from the same family, some people do what I call the simple I love you estate plan, where they just say, well, what we're going to do then is we're going to each leave everything we own just outright to the surviving spouse, with the hope that he or she will then leave everything onto the children equally. That's really not a good plan to follow or a guaranteed plan, because the surviving spouse could change his or her mind. The surviving spouse could be unduly influenced by somebody after the first spouse dies, and that could even be his or her own children that say, hey, mom or dad, you know, we're your blood. You shouldn't really give as much wealth to these other stepchildren as your own blood kin could get. Or, you know, there could be a new spouse or significant other that comes on the scene that now unduly influences them. We can easily achieve their objectives and avoid those types of issues by using a marital trust, where when the first spouse dies, everything is left in a trust, a marital trust for the surviving spouse. He or she can get the income off of it. They can invade the principal if you're for their health support and maintenance. If you're comfortable with it, they can even serve as the trustee of this trust. But the good news is that when that first spouse dies, the first spouse to die goes to their grave knowing where the assets will go when the surviving spouse dies, if there's any assets left in that trust, because it's locked in that they're going to go on to all the children, or at least a certain portion is going to go to their children, so they don't have those issues of possibly the estate plan being changed and their children being cut out of the equation. Another issue that I see more and more frequently are subsequent marriages, especially later in life, where a couple has been married for decades and all the children are from that particular marriage. And then in their 60s, 70s, and even 80s, one spouse dies and then the surviving spouse gets remarried. I mentioned early on that you can disinherit anybody you want, but you cannot disinherit a spouse. So when you have this late in life marriage, if this surviving spouse gets remarried late in life and does not enter into a marital agreement with the new spouse, where the spouses waive their rights, including that right to spousal elective share, and then the surviving spouse dies before the new spouse is entitled to 30% of the wealth of that surviving spouse, even though the surviving spouse's will says, I leave everything to my children from my earlier marriage. And often I will see, especially in later in life marriages where marital agreements are not entered into, because often the new spouse enters this marriage having been married before as well. He or she has children from their earlier marriage. He or she is bringing wealth into this marriage. And he or she says, I'm fine with you leaving everything you own to your kids because I'm going to leave everything I own to my kids. Unfortunately, when the surviving spouse dies, if the new spouse changes his or her mind and decides they're going to take that 30%, there's nothing we can do about it. They're entitled to it. And I always tell clients, in all fairness to the new spouses, in my experience, it's usually not the new spouse who pushes for that 30%. But as you may very well guess, it's usually the children of the new spouse who say, hey, mom or dad, you're entitled to that 30%. You should ask for it. And again, it's too late to avoid it. However, again, if we leave assets to that surviving spouse, even though it's the spouse from this first and only marriage, in a trust that takes care of the surviving spouse for the rest of his or her life, the other big benefit we get with that is that the spousal elective share does not apply to the assets in that marital trust, because when the surviving spouse dies, he or she does not legally own those assets. They're owned by this trust that was set up for his or her benefit. And so we don't have to worry about that new spouse electing spousal elective share, even if they don't have a marital agreement. The last sort of case study, dynasty trust. Because the amount of wealth right now we can pass, again, a married couple, more than $23 million without any estate taxes. And because private trust can last way, way farther into the future than they used to be able to under Florida law. Now they can last for more than 300 years. What we are seeing many clients doing is when they leave their wealth to the next generation, their children, they leave it in a trust. Often it's maybe what I call a beneficiary controlled trust, where their children are the beneficiaries of these separate trusts that get set up for them. And these trusts last for the children's entire lifetime. We don't pay the money out to them at a certain age, because we never know at that age when we pay it out to them what might be going on in their life. Things bad could be happening. They could be being sued. They could be going through a divorce. And so instead, we let them control the money. It's available for their use, benefit, and enjoyment. But if any of those bad things happen to them, whether it's early in their life or late in their life, these bad people, these creditors and predators, including divorces, ex-spouses, cannot get at the assets in these trusts. The other benefit we get is that no matter what those trusts may grow to in size, when children die, typically, if not all, most of the assets will not be subject to estate taxes in their estate upon their death. So the assets pass typically down to the next generation, the grandchildren, free of any estate taxes. And when the grandchildren get the assets, they're in trust again. So they get the same benefits, the protection from creditors and predators, and avoidance of estate taxes upon their death. I can't remember whether it was Mike or Jeff that mentioned about the importance of updating your financial plan. It is very important to keep your, pull out your estate plan occasionally, dust it off, and make sure that it's up to date. We don't recommend to our clients that they have to do that every year. We recommend, though, probably on about a 3-year cycle that they pull out their plan and look at it. Or if any of these types of things happen in their life, some close family members die, or there's new children, or there's a marriage or divorce, things like that would warrant you taking a look at your estate plan, because you want to make sure that when that day comes, that it's going to need to be used and implemented. And hopefully that's not too soon, but when it does, it's up to date, it's fresh, and it's doing what you want to have done. So with that, this is my contact information here. I don't know if there's any questions in the queue or anything. I'd be happy to answer if so. Otherwise, part of my commitment to Mike and Jeff is, again, if people that participate in this program have any questions at all, please feel free to send me an email or give me a call, or I can actually meet with people in a private conference over at Jeff's and Mike's offices there in Tampa, because my office is located in downtown St. Petersburg, if that's inconvenient for you to come here. So.
Hey, Bill, there's no questions right now coming in. Go ahead, Mike.
I was just going to say, are there any questions coming in now?
Not at this time.
Okay.
All right.
Please remember to contact Jeff and I or Bill. We will get your questions to them. We'll help you in any way that we can. And Bill, thank you once again. What is it? Talks cheap, takes money to buy whiskey. This guy is good. He's great for his clients. Thank you.
Thank you.
We got Jason up next, Mike.
Okay, Jason. At this time, I'd like to introduce Jason Hamlin. He's a CPA with the firm of Cohen and Grebe. Jason is, he works with a lot of physicians also. That's why he's here this evening, because of his familiarity with physicians. He's been in practice for a long time. He's known in town as an excellent CPA. And these are questions, we want to bring up some topics, and he is going to talk about tax planning for retirement and other questions that you may have. Once again, ask questions if please. So it's my pleasure to introduce Jason Hamlin, CPA.
Thanks, Mike and Jeff. As Mike said, I'm Jason Hamlin, work with the firm of Cohen and Grebe over in Tampa. We're actually in the same building as Mike and Jeff. And similar to Bill, if you guys have any questions or want to take a look at your situation, you're welcome to come over on a complimentary basis, and I'm happy to meet with you. Or if you have questions as well, Mike and Jeff have my contact information, can share that with you, and you're welcome to give me a call on the phone, text, whatever's best for you, and we'll take a look and try to help you out. So as Mike mentioned, we're going to talk a little bit about taxes today. Seems to be a somewhat popular topic right now, if not a very exciting one. And those taxes are often considered pretty boring financially, although most people consider it interesting because, if they can use it to help themselves pay legally, fewer taxes and ultimately keep more of what they make. In addition, they affect almost every aspect of personal finance, whether you're putting away money pre-tax, whether you're putting it away post-tax, in an after-tax vehicle, a Roth IRA, whatever. Taxes are going to play a part at some point with almost every financial vehicle. So just a brief overview of taxes. Our taxes provide many social benefits, as you guys are probably very well aware with last week's stimulus bill. There are a number of social benefits in there, stimulus payments, et cetera. But in addition, our tax dollars also provide general, infrastructure benefits as well. The roads we drive on, the public benefits that we all make use of. And tax planning can be a pretty critical part of everyone's financial planning picture. Usually, again, as we'll talk about tonight, you don't want to make taxes the primary driver of everything, but you do want to take them into consideration, in anything you're doing financially, whether it's planning for or budgeting, or whether it's planning for a particular expenditure, or whether you're conducting estate planning with someone like Bill, for example. So there are a number of financial strategies to help you keep more of what you earn, and that's ultimately the goal that everyone should have in mind, is to maximize their after-tax dollars. Again, remembering just that, again, tax avoidance is legal and tax evasion is not. So just a key thing to remember there. And another key thing to remember is many of today's tax laws will likely be changed in the future. In fact, we saw some tax laws that were changed just as recently as last week, those pertaining to a set amount of unemployment benefits, additional stimulus payments, other things like that are going to come into play for 2020. And again, so that the lesson you want to get there is, don't base your entire financial plan on what we know currently about tax laws or what laws are currently in effect, because they're very likely to change. So what you want to do is keep abreast of things and try to hedge your bets, by doing a little bit of everything, diversifying in terms of your tax planning. So as far as taxes go, we were talking about the social benefits of taxes that taxes provide. One of those is in the form of additional health care taxes. The Affordable Care Act of 2010 basically added two taxes onto taxpayers who were considered high income earners, those making over $200,000 as single filers and $250,000 for married filing jointly. As you'll notice there, the married filing jointly is not double what the single is. So that's what's often considered one of the marriage penalties of our tax code, where certain thresholds and certain amounts are not exactly double what they are from single to married. So essentially what the Affordable Care Act imposed was a 0.9% hospital insurance tax on wages and self-employment income over the threshold amount. And so basically what would happen then is, as an employee, once you hit $200,000 of Medicare wages, instead of being taxed at 1.45% over and above that, for each dollar over and above that, you're actually taxed at 2.35%. In addition, there's a Medicare contribution tax on your net investment income, again, over that $250,000 threshold for married filing jointly. And what that does is imposes a 3.8% net investment income tax on that additional investment income. And where they end up equaling out is when you take that 2.35% and add it to the employer share of Medicare tax, you get back to the 3.8%, which is equal to the net investment income tax. So that's kind of the rationale for it. They're basically trying to raise additional tax over and above that to help out to pay for the Affordable Care Act. Some tax terms we'll talk about tonight, again, at a very high level, are going to be gross income, which is exactly what it sounds like: all of your income from all of your sources, all of your taxable sources, before taking into consideration any adjustments, any deductions, exemptions, credits, etc. Then we have adjustments, which are special items, typically on page 1 of your return, which are going to be things like, as it says here, student loan interest. The other big ones are health savings accounts contributions, self-employed health insurance, etc. Adjustments will usually lower taxable income and actually lower your adjusted gross income, which will allow you to qualify for certain credits or other deductions that you might not get if your AGI were higher. Speaking of AGI, that's your adjusted gross income. That's the number that a lot of people throw around when they're talking about things like, hey, what do I need to do to get approved for a mortgage? What does my AGI need to be for, X? And it also, as we said before, helps to determine what things you may be eligible for, whether they're credits or additional deductions. It's the key to determining, again, what benefits you qualify for to be subtracted from your AGI. So speaking of subtracted from your AGI, the first one's the standard deduction. And the standard deduction is basically one of the 2 deductions that you get to deduct from your adjusted gross income in arriving at your taxable income. We're all familiar with itemized deductions that are mortgage interest, real estate taxes, sales tax, etc. But the standard deduction for those people who don't meet the threshold to take the itemized deduction is a deduction that everyone gets by default. Again, the standard deduction, we have the 2019 amounts here. The 2020 amounts are slightly higher, but as you can see there, it's a little over $12,000 for single or married filing separately, almost $25,000 for married filing jointly, and head of household is $18,650. One thing to remember here is with the 2018 or the Tax Act that was passed at the end of 2017, what happened is the IRS did away with the dependency exemptions, which people would typically get for themselves, their spouse, each of their dependents. And it was typically a deduction in the neighborhood of $3,000 per dependent. So that Tax Act, which was the Tax Cuts and Jobs Act, got rid of that dependency exemption, essentially doubled the standard deduction for everyone. So that did two things. One is for those people who had very few dependents, it worked out really well because they got a nice standard deduction, but it also ruled out a lot of people being able to itemize anymore. So many people had much less benefit from things like their mortgage interest, real estate taxes, et cetera. So just something to keep in mind there for that. So opposite the standard deduction, or the alternative to that, would be your itemized deduction. So if your qualifying expenses exceed those standard deduction amounts that we talked about, you can go ahead and take your itemized deductions. This is where you need to start maintaining records, though, to support those deductions you take. The standard deduction, you don't have to have any support or any backup for. That's, as the name implies, is standard. Don't need anything to support it. So deductions that you can use that are itemized deductions are typically going to be state and local income taxes, which is going to consist of real estate taxes and the greater of your state income taxes or your sales tax for states that have sales tax but no state income tax like Florida. Medical expenses, although most people don't end up benefiting from those because you have to exceed a percentage of your adjusted gross income to be able to take the medical expenses. And then charitable deductions, which again, those are big ones that you need to have contemporaneous deduction or contemporaneous support for. In other words, when you make a charitable donation, they send you an acknowledgement. You want to hold on to that acknowledgement just in the event that you get audited. So something to point out again with the Tax Cuts and Jobs Act, the state and local income taxes were severely limited to a cap of $10,000. Sounds like a big amount when you're considering, okay, well, if I'm paying $10,000 in real estate taxes, that's a lot. Well, in a place like Florida, it's not really that much. And when you consider that you can take into account your state income taxes or sales tax, then it's even more limiting. So take, for instance, we happen to do taxes for some professional athletes who pay state income tax in every state that they play in. Well, basically now, they may pay $80,000 or $100,000 in state and local income taxes, and now they're limited to $10,000. So you can see where you start to lose out on a huge portion of that deduction. The good news is that just due to things like the alternative minimum tax and whatnot, a lot of people, even though they had those deductions, didn't always benefit from them. However, in addition to that, the Tax Cuts and Jobs Act did widen the tax brackets and lower the rates a little bit in each one of those brackets. So there was a lot of give and take in those in that Tax Act, just like there are in any other tax law changes. So it's important to be mindful of that. There's a lot of things we don't agree with, each of us individually in terms of tax changes, but there are a lot of things too that help us out on the other side. So looking at the 2020 federal income tax tables, you can see here that we have the married filing jointly, head of household, and single brackets. And the interesting thing to note there is that if you're looking at those brackets up through the 32% bracket for single and married, the married is exactly twice the single bracket. Then from there, over and above that in the 35% range, that's where the marriage penalty that I was mentioning before comes into play. Your bracket at 35% for married is about $218,000, whereas for a single person, it's a little over $300,000. The 37% bracket likewise kicks in then at $622 for married, which if you average that over two people is about $311 and change, versus the single that kicks in at $518 for one person. So it's a pretty significant difference there. So when looking at the income tax tables, one of the biggest things that gets misunderstood is the marginal tax rate. We've had a lot of clients that would come to us and say, hey, look, my employer's looking to give me a raise. Is there anything else I should do? Or I don't know if I should take the raise because, it's going to put me into another tax bracket. And the biggest thing there that people misunderstand is that just because you go into that extra tax bracket doesn't mean that now your entire salary is taxed at that tax bracket. It just means that once you get to a certain level of income, that each additional dollar is taxed at that marginal rate. So again, looking at an example, single person with taxable income at 50 grand, the first 98 or almost 9,900 is taxed at 10%. Then you have a portion at 12. And then finally, between 40,000 and 50,000, it's taxed at about 22%. But again, the important thing to realize there is if that individual was making $40,000 and all of a sudden got a $5,000 raise, their tax rate isn't almost going to double on every dollar made. It's just the dollars over that 40,125. So some tax strategies to lower your overall tax bill and or maximize what you keep afterwards. We'll talk about some of those here, but again, it's important to realize that your tax strategy should be in line with your overall financial plan. Again, don't do something purely because of taxes. I can't say that enough. And it's often advisable to take a look at your situation 2 years at a time, and basically reduce your overall taxes that you're paying, over those 2 years. For example, if you're in a situation where you may receive a big bonus this year and are anticipating making less last year or next year, or vice versa, you may want a time when you do certain things or put away money for certain things. So one of the big things and the biggest bang for your buck in terms of saving tax dollars is to participate in an employer-sponsored retirement plan. We all know that as our 401k, our 403b, et cetera, where we can put away dollars tax-free and pre-tax, so tax deferred, to reduce our current taxable income. The thought there is you're getting a current deduction, so it's a known deduction at a known percentage, which provides a level of certainty, and it also helps to reduce dollars that we're paying out now for taxes. Obviously, nowadays 401ks, 403bs have a Roth provision, which is not pre-tax, but we'll talk a little bit about that momentarily. But again, that's more of a big picture thing where you want to talk to a financial advisor. With the traditional 401k or 403b, however, it provides long-term tax benefits because your principal and any earnings grow tax deferred until you withdraw them later on in retirement. Occasionally, as we saw last year with COVID, there actually was the ability to withdraw some of that money early without paying what's called with the early distribution penalty if you were under age 59 and a half. Kind of some little one-offs there that we probably won't see again, but it's just important to be aware of things as they come about. And that's why, it helps to talk with your CPA or your financial advisor, in conjunction with doing your tax planning. So if you don't have the ability to contribute to a 401k or 403b, your next best option is going to be a traditional IRA. You're typically limited on that, however, to $6,000 per year, $7,000 if you're over 50, versus a 401k where you can put away between $19,500 and $26,000 in 2021. That $26,000, the extra $6,500 is if you're over 50. So depending upon your income, you may be able to deduct your contribution. So basically, for example, doctors who are in residency may be able to deduct the contribution. Probably most doctors who are in practice probably are not able to deduct their contribution. Similar to 401k, it provides long-term tax benefits of tax-deferred growth. Another strategy is to contribute to a flexible spending and or health savings account. Flexible spending, while still around, is somewhat less popular now just because of the prevalence of the health savings account. People used to use flexible spending in the form of what's called an FSA for medical expenses or an MSA, and they would put away money pre-tax to use for medical expenses. The downside being is if you didn't use it, you typically lost it at the end of the year, versus the health savings account where you can put the money away pre-tax, use it for medical expenses this year, or if you don't use it, you can use it next year, or for that matter, you can treat it as another IRA and let it sit aside and grow pre-tax. On a pre-tax basis, a tax deferred basis until you reach age 59 and a half, and again, treat it like another IRA. One flexible spending account or spending aspect that is still popular is typically going to be the dependent care expenses, and that's going to be up to $5,000 each year of pre-tax deferrals for stuff like child care, camps, et cetera, that qualify, for your dependents. One thing to be mindful of if you do that, however, is that both spouses must have earned income. So whether it's self-employed income on a Schedule C or a partnership pass-through, or W-2 wages more commonly. If they don't, that $5,000 deferral that you're not planning to have taxed will simply go right back into taxable wages when you file your return. Again, as I mentioned, with flexible savings accounts, it's typically a use it or lose it kind of a thing. And if you don't plan well on it, you basically you save it pre-tax, but it's gone at the end of the year. So some tax strategies to consider before you retire. And this is typically a one-off situation where you might receive a severance paycheck or something of that nature, where you might be anticipating a much lower income in the following calendar year. So in that event, you might want to wait till, say, till January 1 to officially retire, at which point you can get your severance paid out in a year where you're not going to have significant wages in that year, assuming you're not gaining employment with another employer at that point. Again, probably a one-off or a very rare occurrence during most people's lifetimes. Itemizing deductions. Again, consider whether it's more beneficial to itemize or take the standard deduction. Pre-Tax Cuts and Jobs Act, there was a lot more flexibility with being able to double up on certain itemized deductions. You can still do that to an extent with your charitable deductions, or if your property taxes are low enough, you can double up on those in, say, odd years and every other year. So every odd year or every even year, and then take the standard deduction in the other years. That will allow you to take the most benefit from those deductions, where you can exceed the standard deduction in the odd years, and then in the other years, just take the standard and benefit that way. Whoops. Again, consolidating deductible expenses. That's what we just talked about with the charitable contributions. You might also want to consider donating appreciated long-term securities. The benefit there is you can get a really nice charitable deduction at full fair market value, and you get away with paying without having to pay any tax on the capital gains as well. So that's a really nice kind of double benefit right there. Also, if you're going to sell some securities at a loss, or I'm sorry, if you have a security that's in a loss position, however, you'd want to sell that first so you can take advantage of the loss and then donate the cash to the charity. That's kind of a rare situation. More often than not, it's donating appreciated securities. Non-essential dental and medical work, you might want to, again, combine all of that into 1 year, but that's going to be a much rarer deduction for most people because it's typically a 10% of adjusted gross income floor. So as your income gets significant, it's much harder to deduct those expenses. Taking advantage of adjustments and tax credits. Adjustments and credits can make a huge difference in your overall tax bill, as it says. Again, student loan interest deduction, most of you will probably not qualify for that because your income will be much too high. But again, if you are eligible to contribute to a deductible IRA or put away money into a health savings account on a pre-tax basis, that's certainly going to help you out as well. Other credits that may be available, other adjustments that may be available are the tuition and fees deduction, which you can usually optimize between doing that and the American Opportunity Credit or the Lifetime Learning Credit, which are also valuable, but again, for people who are under a certain income tax or under a certain AGI threshold. Again, there are some other credits that are available regardless of your taxable income or your adjusted gross income, the child and dependent care credit. However, that does phase out as far as the percentage that you're allowed to take. Most people, once they get past a certain amount of income, are usually only limited to 20% of the first $3,000 of child and dependent care expenses, up to $3,000 per child with a maximum of 2 children. So as you can see, you're only going to max out at about a $1,200 credit right there. Adoption expenses, those are a more significant credit, but nowhere near the cost that it takes to adopt a child. And then credit for things such as foreign taxes paid, which a lot of you will see on your investment statements or the 1099s each year when they come out. It's typically listed below the dividends in that section of the form. Another strategy is to use capital loss rules to your advantage. Again, capital losses can typically be used to offset capital gains, which makes sense. And if capital losses exceed capital gains in a given year, you can go ahead and claim up to a $3,000 net capital loss to offset your other income. So any losses over and above that $3,000 will be carried forward to offset gains in future years. So the one thing you really want to do if you're anticipating a large capital gain is you want to make sure that you take advantage of any losses in the year where you have a large capital gain. The last thing you want to do is have a capital gain in 21 and then in 2022 sell something at a huge loss that you could have otherwise used in 21 to offset a large capital gain, because you can't carry those back. The wash sale rule is something else to be mindful of. If you sell a security at a loss and you're planning on taking that loss, you better not buy that same security back within 30 days, or then it's, as it says there, it's considered a wash sale for purposes of taking that tax loss. So one alternative to that is you can buy a similar security, whether it's a similar fund or, for instance, a stock in a similar competitor that ultimately is performing in a similar way. Another strategy is when to buy and sell mutual funds. Typically, if you purchase a mutual fund after the annual distribution of capital gains, you avoid being taxed on that distribution, and likewise consider selling them prior to them paying out that large dividend, so that you don't have to pick that up as income. And again, it's a weird idiosyncrasy of mutual funds, but it's not that you're getting that dividend when it's paying it out, because typically it gets put back into the fund in a way that it's not increasing. It's not playing out like you think it would. So in some cases, again, by selling those before they pay out those capital gains, if you're under a certain threshold, you can actually take advantage of the lower capital gains rates on a long-term basis, instead of getting ordinary income tax on non-qualifying dividends. So that's something important to keep in mind as well. Some other tax strategies are to position your assets in different types of accounts. Again, you want to have things that are more tax efficient or are not paying out or are not showing huge amounts of income in your taxable accounts, where your less tax efficient investments would be in tax deferred accounts like your retirement accounts, IRAs, etc. Be careful not to, again, lose your itemized deduction or lose your deductions if you can take advantage of them. If you have, like in this case, more itemized deductions from a business loss, or medical expenses or charitable contributions, and you can use in a given tax year, you want to make sure you time those so that you're not losing out on any of those deductions, so that you may want to take those in one year versus another if you have any control over them. And you won't always have control over some deductions. It's just a basic fact that you're not going to be able to always control everything, but it's to the extent you can. So, in years where you have lower taxable income, last year was one of those years. It was a prime opportunity when if people might have been, in a position where their income was going to be down, they might have want to consider converting all or a portion of a traditional IRA to a Roth IRA at an advantageous marginal tax rate. So at a lower tax rate than they would have ordinarily been in. Another benefit to doing it last year is obviously we saw a huge market dip last year. So when you convert that traditional IRA over and it has a much lower market value than when the market came back up, that's one of the few opportunities you have to truly avoid income taxes on a permanent basis, is on that appreciation right there, or on that bounce back in the market once you've converted to a Roth IRA. Again, taxable investments, should always consider the tax strategy there in terms of what those investments are throwing off, whether you're investing in growth stocks or small caps or whatnot. And that's where you really want to make use of folks like Mike and Jeff, because they can go ahead and plan with us and look at your overall picture to see what's going to make the most sense for you, whether it's taxable investments, whether it's municipals. And again, all of that depends on where the market's at the time or where they perceive the market to be going. In terms of taxable investment income, some of those forms are interest income. That's typically money, again, you receive for loaning money, or money you have in savings accounts, CDs, bonds, etc. However, it seems like nowadays the interest is so low that I'm not sure most people actually recognize it when they receive it anymore. Dividend income, distribution of a portion of a company's earnings, which again, most of the time that'll be reflected on, or actually always is going to be reflected on a 1099 at the end of the year. And again, that's going to be when a company does really well. That's going to be like, ExxonMobil or any of those other companies that pay out those dividends. It's typically going to be based on a dollar amount per share that you own. And one of the benefits of tax acts, one of the tax acts probably in the last 15 years was the advent of the qualified dividend. And basically with qualified dividends, which are going to be most of the companies that are paying dividends these days in the United States, qualified dividends are taxed at the long-term capital gains rates, which means that if your long-term capital gains rate is 15 or 20%, you're going to pay that versus paying at your marginal rate of 22% or 33% or 37%. So capital gains, again, a capital gain is basically what you experience when you sell an asset for more than you purchased it for. And again, as it states there, you don't have to go ahead and report that capital gain until you actually sell that asset. So just because an investment is increasing in value, you're not taxed on that until you dispose of that asset. Assets held for more than a year are typically taxed at the long-term capital gains rates, which again, as we pointed out, can be 15 or 20%, or in some cases 0%, depending on whether you're in a low enough tax bracket. Assets held for 12 months or less are taxed at your marginal rate or your ordinary rate, just like interest income or taxable wages, et cetera. One thing to be actually just cognizant of is the fact that there are certain things, especially in this day and age when people are into collecting things, whether it's, collectible coins or stamps or anything of that value that people sometimes want to make money on. Those are considered collectibles, and those are actually taxed at 28%, regardless of the term held. Or I'm sorry, once they hit long-term status. Otherwise, less than 12 months, they're still taxed at the lower tax rate. I'm sorry, at your ordinary rate. So your investment tax rates, again, your long-term capital gains rates that we talked about before. So you can see there that there's a portion of your taxable income where capital gains are actually in the 0% bracket. And that actually came into play a lot for a lot of people last year with respect to retirees, because you had a lot of retirees that had the option of not taking required minimum distributions. So you were in that year able to maybe sell things at a gain that you otherwise wouldn't have sold and basically pay zero tax on it, on the gain at that point, because you didn't have to take that RMD. Again, not going to be something that most of the folks on this call would be able to take advantage of. But again, it's always good to be aware of what tax provisions are at the time when you're, in each tax year. The investment tax rates, again, we talked about that net investment income tax before. That's that 3.8% that came about with the Affordable Care Act. Again, it comes into play for married filing jointly over 250, which is halved for married filing separately, and then single or head of household, like we said before, was $200,000. The tax exclusion for home sale gains. This one's a big one here in Florida, and it's a really valuable tax benefit that you can take advantage of. And basically what that says is you can exclude up to $500,000 of gain on the sale of a house, provided that you meet the ownership and use test, which we'll talk about in a second. That $500,000 for single people for single filers is halved to $250,000, but still that's a considerable exclusion from your taxable income. If you're able to, realize a gain on the sale of a property like that. So basically, though, to qualify for that, you will have had to lived in and owned the house for 2 of the previous 5 years, ending on the date of sale. And in the previous 2 years, you could not have excluded gain on a sale of another primary residence. In certain circumstances, and those are very narrow exclusions, you can take a prorated gain, prorated on that $500,000 or the $250,000 based on the amount of time you lived in the home. One other thing to consider there is when we talked about the ownership and the use tests, only one spouse in the case of married filing jointly has to pass the ownership test. But in order to have the full $500,000 exclusion, both spouses must pass the use test. So spouses must live in and use the house as their primary residence in order to exclude that gain. That's a big one there. And it comes into play a lot when you have either the house is in one spouse's name, or if one spouse owned the property and then got married, and the other spouse didn't add their name to the deed and or the mortgage, which in that case I wouldn't add my name to the mortgage either if I didn't have to. So something to consider there. And it's a great way to exclude a significant gain or significant amount of income from your taxable income, especially here in Florida with the property values that we have. So that's all I have for today. Sorry, I went kind of fast with that, but I know we're limited on time. So I just wanted to go through that. If anybody has any questions, if you have them now, let me know. If not, let Mike or Jeff know, and they'll give you my contact information, and we can, get your question resolved and, hopefully get you on the right track.
Do we have any questions that have come in yet, Doctor?
No, I don't see any on the chat box at this time on
Okay.
the tax information.
Okay. Jason, thank you very much again.
Yes, sir.
We appreciate your knowledge and your time with our physicians.
Yes, sir. Thank you, guys.
Thanks,
Okay.
Jason.
Thank you.
Thank you,
And
Jason.
And Jeff, do you want to start the next part? Because now we're actually going to go into retirement planning from the financial end. Go ahead.
All right. All right, chapter 2. So this chapter, we're going to cover just all the variables that are involved in building a retirement plan, and how to watch out for things like inflation and longevity risk. So Mike, we want to talk about inflation?
Yes. Look at that chart right now that you're staring at. That shows you how high inflation can go. Okay. We've been so spoiled the last number of years with the rate of inflation, but it can go get higher. And the thing is this, it dramatically affects your wealth accumulation and your buying power, your spending power. That is something you have got to take into play every time you think about how much am I going to need to buy this item 5 years, 10 years from now. You've got to take it in when you're figuring out how much money you need for retirement. The inflation factor has got to be in there. Okay. Over the past 28 years, the inflation factor has averaged between 1.7, 2.4%. It's starting to edge up a little bit now. We usually run inflation at 3. Now we're starting to run it at 4. Jeff.
Yeah, that's a good point, Mike. There's a lot of talk that inflation's on the rise now. So, maybe using 3. 3 is definitely a good number. If you want to be more conservative, maybe 4 may make sense as well. So why is inflation such a big deal? Well, because people are living longer, like we talked about, and it's going to impact your retirement. A lot of people plan to life expectancy, but life expectancy means half the people die before and then half the people die after. So that's a little bit flawed. So if I plan to my age, my life expectancy is a 50% chance I'd run out of money if I lived longer. So we use 100 personally. So when you run your retirement plan numbers, if I want to retire at age 65, I still need money left by the time I'm age 100, not just life expectancy. Okay. Now, because people are living longer and use age 100, inflation plays a huge role in that because you're looking at 30, 40 years of retirement.
Before you switch slides, Jeff, I just want everybody to just look at how long your money has to last, because yesterday, you might have been 30 or 40 years old, but you're not. You're one of these numbers. So inflation is a real thing that you have to plan with. Go ahead, Jordan.
So if you use the 3% inflation rate, this is just kind of eye-opening that $1 today, 30 years from now, at 3% inflation, you need $2.43 to buy the same goods and services. So I think see a huge increase over a 30-year period. If you look at it in terms of dollars, $5,000 today, 30 years from now, $12,000 at a 3% inflation rate.
And that's at a 3%.
Yeah. And if a lot of people say, oh, I'll cut my expenses when I retire. Well, that doesn't happen. Mm-mm. We don't really run into too many people who want to reduce their expenses when they retire. Mm-hmm. But what will you have to reduce your expenses to adjust for inflation? $5,000, 30 years from now, would buy the same goods and services that $2,000 does. So cutting your expenses is not an option. So you have to build your plan based on using inflation, 3 or 4%. Okay, so how much do I need to retire?
Yeah, if I can make a comment there.
Yeah,
I love
absolutely.
it when these experts say you're going to need 75 to 80% of your income when you retire. Well, I wouldn't want to be in the same room if I had to tell our clients, so by the way, you're retiring tomorrow, so we're going to reduce your income 20 or 25%. Jeff hit very good points when he just said your expenses may go down when you retire, maybe, but then you're going to have more time to spend more money. So we plan for 100% of your income. It's your decision, but don't discount it too much, because you haven't worked all your lives and saved the way that you have to take a pay cut the day you retire. Good.
Yeah, the real way to figure out what you're going to need is a cash flow worksheet, which we'll talk about. But when we see physicians come in and they're looking at their retirement numbers and they do the cash flow worksheet, very rarely does it come in under 100%. Sometimes it's 120% because they're going to travel. I don't see 80% or taking a 20% reduction too often.
Yeah.
This is just kind of bringing it all together. If I retired at age 70 and I planned to age 100 and I needed $100,000 a year of income, what this shows is that you need $2 million in your nest egg in your retirement accounts in order to produce $100,000 a year, make it last for 30 years, keep up with inflation at 3%, and at a 6% rate of return, you would have $0 at the end of 30 years.
$0 left at the end. So
Yep.
These are not conservative numbers.
If you needed $200,000, you need $4 million in those accounts. So as you can see, they start to get up there pretty high. So you need to make sure that your projected savings amount is going to get you to that target nest egg number in order for it to produce income for 30, 40 years and make that money last.
Do you see why it's so important to start saving for retirement early on and make it an automatic habit that you don't have to think about?
Absolutely. All right, section 3. Mike.
Oh, I love this one. So what are the biggest roadblocks that people have in trying to accumulate wealth for retirement? As we go down this list, we'll take turns on this list, but most of it are all things that they don't do. It's not things that they do. It's what they don't do. You know, they don't define how they want their retirement years to be. You know, something as basic as that. Good, Jeff?
Yeah, that is true. That was chapter 1, the lifestyle planning part. Those lifestyle goals, if I want to travel and I want to go see the grandkids, that's all going to cost money, which is number 2, financial goals. So the lifestyle goals trying to drive those financial goals, and you need to set those goals as well.
Yeah, they don't make a commitment to be financially successful. I think the profession that you're in is not as much a problem as it is discipline in keeping your money. So you will be financially successful, but you need to know that, and you need to take a financial inventory and cash flow and net worth. You want to comment on them, Jeff?
We're going to talk about them in a minute. We actually have slides coming up.
Okay.
You know, the biggest bullet point there is seeking professional assistance and building a team. You know, you should have a CFP, a CPA, an attorney, like we had for the panel tonight, and all that. When everyone's working together, you can generate strategies together and make sure you're covering all facets of building a good, strong financial plan. Number 4 is investing early in life on a regular basis. This goes back to forced systematic savings.
Yes.
If you're not retired yet, you got to consistently save those dollars, have it set up systematically, and get the money into those accounts to make sure you hit your goals.
You don't want that make the decision, am I going to save this month? You need to set up automatic systems where you automatically steal from yourself before it gets to you. That's why physicians grow such a large portion of the retirement money in their qualified plans, because it's taken out by the practice or the hospital or whatever before you get a chance to spend it. Learning how to steal from yourself, forced systematic savings. You can take the forced out, but good.
Number 5, use tax loss to your advantage. I think Jason just covered that very effectively. And, you know, in our world, on the money management side, you know, make sure that you're taking advantage of the $3,000 offset every year. And you can take those losses, making sure your taxable portfolio is trying to produce as less taxation as possible. All very important to try to save those tax dollars.
Yeah. Oh, another thing, don't allocate assets properly or just as needed. I don't want to get into it too long, but asset allocation is the biggest effect on a total portfolio, because people like us, we can talk a good game and say, oh yeah, that's going to do great, or this area is going to do great. But all that we really know is that this year might be a U.S. large domestic cap. You know, next year it could be international small cap. We don't know the classifications. We know that 91% of the return in an overall portfolio comes from asset allocation. And it is so important to know that allocation and then adjust it as needed.
Yeah, in the form of rebalancing. You know, in your retirement accounts, they'll rebalance for you. Nice and easy. Do that at least once a year. Plan for the unexpected. We call this the what if scenarios. What if I died? What if I became disabled? What if I got sick and had a long-term health situation? I've grown all these assets, and I've probably had more money. The people on this call probably have more money than they've ever had in this phase of their life as they're approaching retirement. You want to make sure you protect it from all the what if scenarios.
Yeah, so that's an asset protection thing that he just spoke about, which is critical. But the other thing that's unexpected, and one of the speakers earlier mentioned, was talking about insurance, Bill McQueen. There's nothing, I mean, it's sad when anything happens bad to people, but when I'm sort of paranoid about disability, just so you know, but when a physician, you know, their biggest asset is their ability to earn money. When they become disabled, if they don't have the protection and they implement these things, it is so sad what happens. You know, it's not the lawyer that gets the first call, folks. You know, it's us. Our phones are on 24/7. When things go bad, we get it. And that, not being prepared for the unexpected, is so sad. Go ahead, Joe.
Yeah, taking money out, number 8, taking full advantage of employer benefit plans, making sure you're utilizing all the opportunities that you have with your employer. And then also when you do retire, make sure you execute the distributions correctly. Make sure you don't pay any unnecessary taxes. And we're going to cover that in the next chapter. Number 9, Mike.
Don't properly plan for their estate. People have been pretty lax on that over the last few years because they've been very favorable tax rates. But let me tell you, every CPA I know is worried like heck about taxes right now. So you've got to make sure that you stay up to date on that.
Number 10, you know, we've really been hammering the need for a financial plan. It needs to be comprehensive, it needs to be implemented, and it needs to be updated at least once a year.
Yeah, if you remember nothing from this class this evening, remember to have a financial plan, do that, and also review your wills and trust. Oh, here we go. CFPs, CPAs, there's 2 things dear to our heart. The 2 basic documents in accounting and finance are a statement of net worth, okay, which is a look at a photograph of what you have right now, what you have and what you owe. And then you take your total assets minus out the liabilities, it gives you your net worth. That is such an important statement. That, and the other most important statement is the cash flow page. Okay, a cash flow tells you how much is coming. It's more like a video. It tells you how much money's coming in and where that money is going out. Jeff alluded to earlier that we have a form that you can use as a budget statement. I'll tell you, you might not like it when you first see it, but if you work your way through it, it is revealing. You've got to know what your cash flow is like. Too often, we'll tend to fool ourselves when it comes to our cash flow. But if you do a budget sheet like that and get the real numbers, it'll help you tremendously in your planning and also give you a good peace of mind.
Absolutely. You know, when you do a cash flow worksheet, it's great to have one right now for what's coming and going out. But if you do one that forecast derived from your lifestyle planning. So if I look at one as if I'm retired, my travel budget's probably going to go up. Some other expenses may go down, but it's a good exercise to do one now and then look at what will be different at retirement and do one also, because
that's a good point.
Your retirement income need is predicated upon that. So you don't want to underestimate your retirement need and then get there and you're spending 10 or 20% more than you anticipated because your plan may not be able to sustain that distribution. So that number is very important to understand when you retire, which is how much income am I going to need? All right. On to IRAs, 401ks.
So these are just what are your personal retirement sources? Well, first is going to be traditional IRA. Okay. Now we love Roth, and we'll get into that. But an IRA is just a way for you to put away money. And when you put away the money, you're allowed to put away $6,000 a year. If you're over 50, you're allowed to put $7,000 a year away. And it gives you the chance to take a deduction for every cent that you put in. Okay. And then it grows tax deferred in addition. And also in addition is everything in a qualified plan, because an IRA is a qualified plan, is asset protected. The problem is when you take it out, it's all taxed at ordinary income tax rates. So IRAs are very basic. Good, Joe.
Yeah. So the question becomes, well, can I make a deductible contribution to my traditional IRA? Here's the chart. If you're covered by a retirement plan at work and you're married filing jointly, the number's pretty low. It's $124,000 of income married filing jointly. And for single filer, it's $65,000. So if you've got a plan at work, the likelihood of you being able to deduct your contribution to an IRA is pretty low.
It isn't going to happen.
Yeah, if you don't have a plan at work, which is very unique, most people have a plan at work, then you are able to deduct a contribution always, no matter how much income you make. And if it's a spousal situation and one person has a plan at work and the other one doesn't, then there's a different formula, but it's still a pretty low number.
Yeah.
Yeah, here it is there. It's like less than 196,000 married filing jointly in that scenario.
So you won't be using IRAs probably at this stage of your life. You'll probably roll your qualified plans into one eventually, and we'll get to that as time goes on.
So on the Roth IRA side, Mike had talked about you may get a deduction on the traditional, but everything's taxable on the way out. On the Roth, no deduction, but everything is tax-free on the way out. So that's
very good when you're retiring, buddy. Let me tell you.
That's a really good benefit there. You've got all these years of growth, and even if you're in your 50s, if you're planning age 100, that's a lot of years of growth that you'll get tax-free. So can I contribute to one of these or not? The income test is a little bit higher. You're looking at below 206 married filing jointly and below 139 for a single filer, but still not huge limits on the Roth side of things. But if you get money in there, it's great. Now, conversions, if I have a traditional IRA and I want to make it a Roth IRA, can I do that? Yes, you can, but you have to pay tax on the conversion. So if I had $100,000 and I wanted to convert, I would convert it, but I would owe tax on that $100,000. So let's assume I'm in a 25% bracket. I'd have to have the $25,000 in somewhere else to pay the tax. So I don't want to withhold the money out of that account, because that's money that got into my retirement plan that I had to work hard to get it in there. I don't want to have it taken out just to pay the tax. So that doesn't make much sense. Times to convert in down markets is a really good time to convert. Like in 2008, when the S&P was down 38%, we converted a lot of people over at that point. So you still hold the actual investment, but you convert it while it's been sold off. And then now it's got all tax-free growth when it takes off again. So not a bad little strategy there. There is also something to bypass the income test on Roth. It's called a backdoor Roth. Now, this works assuming you don't have any other traditional IRAs. So if you don't have a traditional IRA, step one. Step two, then what you do is you make a non-deductible contribution to a traditional IRA, and then you convert it, and you bypass the income test on the Roth. So this is contributory money. I'm still doing my 401k. I'm maxing that out, but I want to add additional dollars to my Roth for me and my spouse. You can do the back door and get an additional $12,000, $14,000 in there if it's a couple, or $6,000.
Yeah, the residents and the fellows love that.
Yeah, real common for the
low enough to do it.
Absolutely. All right, let's talk about employer-sponsored plans, defined benefit and defined contribution.
They're pretty easy, pretty quick on this.
Yeah.
On your retirement plans, whether it's 401k, 403b, defined benefit plans. It means that your employer, when you retire, is going to give you an income stream. They will give you a guaranteed income stream when you retire. That's a defined benefit plan. Once again, the defined benefit plan is usually paid by the employer, not the employee. But they give you a defined benefit as opposed to
there, Mike?
Contribution. I wanted to get into.
Okay. Yeah. So defined benefit are pension plans. A defined contribution are 401ks and 403bs. 401k is the section of the IRS code for-profit organizations. 403b is just for nonprofits. So not a big difference there. The funding amounts each year are the same, $19,500 with a $6,500 catch-up provision. Now, when you look at the 401k space, you have choices. You can do the pre-tax traditional contribution, or you can do a Roth contribution. You get the deduction for the pre-tax, or you don't get a deduction for the Roth, but it's all tax-free. The money that they give you will have a vesting schedule. So if there is a match, there's a certain period of time that you have to hold those dollars and work there, or you don't get all that money if you quit the job and move on.
Right, they'll do it by percentage, by the number of years you're there.
Yeah, usually it's like a 7-year.
7 years. They can do a 7 years. Sometimes there's a 10-year cliff.
Yeah,
you have 100% after that.
Yep. Now, you do have to wait till 59 and a half to take the money on the 401k plans. There's a 10% penalty for early withdrawal. And 403bs are pretty much, they operate the same.
Same
the limitations of these, you're limited to the investment choices inside these plans. So that is one drawback. But we all know that you need to fully fund those plans. It's the easiest way to get a lot of dollars into a plan and get a tax break.
Fully fund them, fully fund them, fully fund them.
We put SEP on here. You don't see a lot of physicians doing SEPs. Maybe if they had another business, they may want to contribute to a SEP. And aside from their being a physician, you can put a lot of money in there. You can put up to 25% of that salary from that business into the account. But whatever you do for yourself, if you have any employees, you have to do the same. And they're 100% invested immediately. So, sometimes you see them used, not too often.
You don't see them anymore.
Yeah, we don't see them too often.
You have to invest all your employees right away.
Yeah, you don't see too many simple plans that often either. These were kind of a start out plan. So maybe if you started your own practice, you might want to install a simple plan. It was low maintenance, low cost to put in place, and in a kind of a structured match program. But they've got it done away with them because 401ks have got very inexpensive to administer. So they just choose the 401k because it's got a higher contribution limit. As you can see, annual contribution only $13,500 versus with a $3,000 catch up. So
401ks are simple, they're easy to put in, they're inexpensive to run, and they're very flexible.
All right. So now let's talk about when you retire, how you take money out of all this stuff and make sure that you do it right.
Boy, and doing it right is very careful because the penalties will kill you.
Yeah. So the first thing is you can leave it in the plan. If you leave it in the plan, you're limited to the investment choices inside the plan. You know, if you've got a good allocation there and you're happy with it, great. Now, a lot of people think that they're not paying fees inside your 401k. You are paying fees inside those accounts. You don't really, sometimes you don't see them because they're hidden in the management expense. But you want to understand what you're paying before you make that decision, because oftentimes they aren't as inexpensive as you think. And you're limited to the choices inside the plan as far as the investment. So it's hard to realign the portfolio when you might only have 2 or 3 fixed income funds, and that's the only choice that you have when you're trying to shift to a more conservative portfolio when you retire. You can transfer money to your new employer's plan. If you're not retiring and you quit this job and you get another job and they have a plan, you could roll into that next plan if you like their investment choices.
A lot of times they don't let you continue to fund them once you leave.
Yeah. You could also roll it to an IRA. That's probably the most common. You roll it into an IRA, you take control of the assets. If you're working with a professional, you work collaboratively together to design a plan, but you have the whole world of investments to choose from. So a lot more flexibility in the asset allocation design, which is very important. You know, asset allocation is key. So it gives you the ability of a lot more choices to design the right allocation and choose the best funds out there.
Yeah, listen to what Jeff just said on that. And another advantage is that an IRA is much easier to work with when you start to make withdrawals. When you're in a 401k or you're in a defined benefit plan, in those corporate plans, they're not designed for distribution as much. The way an IRA, people usually just roll over into IRAs because of the ease of disbursement as you start taking income from your assets that have grown. Good, Jeff.
Yeah, that's a very important point. You know, when you do retire, you're going to have to take required minimum distributions on these accounts at 72, which we'll talk about in a minute. But the setting up a systematic distribution and creating that resemblance of normalcy when you retire is a big part of that. You might think it's not, but when you retire, you have to look at your liquidation order, which are what accounts am I going to tap into first, second, and third? How am I going to do this in the most tax efficient way? And how am I going to do it where it just gets direct deposited into my bank account? It makes my life nice and easy. It's just like you're still getting a paycheck, but you're just paying it out of your own investments. Doing that out of an IRA is much easier than setting up out of a 401k.
Yeah, and it's so important as you retire that you're used to being paid a certain way all your life. You know, the money now goes into your account and you're used to it. You need to make sure as you retire or start to slow down that your income keeps coming in the exact same way. It's a mental thing, but that way, if it goes directly into your checking account, it's one less worry you have. But 401ks are not as easy to do as an IRA is. Very good point.
Yeah. Receive a lump sum distribution. You wouldn't want to do that. That's all taxable. So unless you needed the money, which I don't think that would be the case. And then receive monthly annuity payments. We're going to talk about these options in a little bit. But that is one other option of turning into guaranteed income if you don't have a pension plan. So,
Jeff.
Yep.
Hey, we have a question from one of the attendees on the retirement plans. They mentioned a 457 plan.
Okay.
What is the benefit of a 457 plan? They write, some things I've read indicate they are not always beneficial, and I don't quite understand how they work. Is now a good time to talk about that?
Yeah.
We can talk about 457s. You know, it's really the thought behind the 457 is that you're deferring income for further down the road. And it all depends on tax rates from where it's going to be now until when you take it out. And we think the tax rates are probably going to be higher. So it may not be the best advantage of using the 457 They're mostly funded in like municipalities and
Right.
governmental 457s.
Usually
So we don't
government
see them a
grants,
ton. But you got to just read the print of the 457 and make sure you understand it fully, because there is variations in the differences of some of the different 457s out there. Because when they're developed, there's the way that it's designed can be a little bit different from one plan to another. So you got to really do your homework there and make sure you understand what the true benefit is. A lot of times it's you expect to be in a lower bracket when you retire, but we don't see that
No.
with physicians. We see that you're going to be taking out more money when you retire. You might be making a little bit less, but you're still living on a high amount of income. So you're going to be still in a high tax bracket.
And a 457, you have to read the fine print because they're done so differently at times.
Yeah, that's something we can help people with if you.
Yeah,
If
that's
So
a
you're saying there's
complicated area.
different
That's
there's
a good
different
question.
varieties.
Yeah, the varieties.
There's
Yeah,
different varieties. They're not all like a Roth IRA that are tax
No.
deferred.
No.
Okay, fine print. Thank you.
Right.
Now, on the rollover piece, if you decide you do want to roll it into an IRA, you never want to have the check made payable to you. They mandatorily have to withhold 20%. So if I had $1 million in my 401k account and I wanted to roll it over, I need to find out where I want to roll that money to first. And they have made the check payable to what's called the custodian. And the custodian is where who's kind of handling or overseeing the IRA account for you.
Yeah,
Let's say I was going to move it to Vanguard. I would have the check made payable to Vanguard, no tax withholding, and the full $1 million goes over. If I had them send the check to me, they're going to withhold $200,000. It's 20%. I've got 60 days to get that $20,000 to $200,000 back into the account. I don't want to do it that way.
And it doesn't happen. Nobody makes the 60 days.
Yeah.
For some reason or another, if they do that and they just don't make the 60 days and they pay huge penalties on it. So you have to be so careful with that. It's got to be made payable to the receiving house.
Yeah, and let alone you got to come up with those extra dollars. In that big example, $200,000 is sent to the IRS. You got to have an additional $200,000 to get it in within 60 days. That's the problem.
That's tricky. It doesn't happen.
Yeah, don't make that mistake. Very easy. Just know where the money's going.
Yeah.
This is if anyone has any publicly traded stock in their 401k plan. So let's work out if I work for a publicly traded institution and they have their own stock as an option in the 401k plan. When you decide to retire and you roll out of the plan, there's a strategy called NUA, net unrealized appreciation. This allows you to pay long-term capital gain on that stock versus ordinary income, because everything coming out of your IRA is taxed as ordinary income. But if you execute it under the net unrealized appreciation, you can save yourself a considerable amount of money in taxes if you structure it the right way.
And that's something that they may change the benefits of that with the new administration. So.
Okay, we're going to jump back to defined benefit plans here for a minute. When you have a defined benefit plan, all they're really doing is giving you an annuity payment. So these options are also the same as if you went out and purchased an annuity from an insurance company and chose one of these payouts. The most common payouts are here. So a single life option is only paid on your life, and at your death, it ends. It's going to be your highest payout amount. Right. So in this example, it's $2,875 a month. Well, my other option might be, well, I'm going to take the 100% survivor option. What does that mean? Well, that means if I die, my beneficiary will get the same amount that I was receiving. All right. So in this case, it's 100% survivor. I die, they still get that $2,010 a month payment. If a joint 50% survivor, if I'm getting $2,500 and I die, my surviving beneficiary will get the $1,250. Okay. So those are your choices.
Make a comment here, Jeff.
Absolutely.
This is where many mistakes are made, because as someone doesn't have a professional working with them, but they look at the higher number and there's almost an instinct that that's what they want. Okay. But it is a huge mistake if you do that and you have a spouse. You've got to take care of your spouse. Don't let that number fool you. Make sure that you take care of the spouse, because once you do it, it's too late. And that's made a lot a lot of times we hear, well, I thought you could change it. You can't.
Irrevocable decision.
Yep.
We're going to go back to defined contribution. If you have a 401k and you're not happy with the choices, but you're still working there, one option is, and they don't tell you that this is an option in most cases. You have to call and ask if they allow it, but you're allowed to withdraw and a rollover a portion of your value of your 401k into an IRA, but you're still working there and still making contributions. So that would allow you to diversify in an IRA, but you still keep the 401k, and it's done on in a tax-free basis. You don't have to pay the tax when you roll the money over. You will when you start taking the money out. But this is for diversification purposes.
Yes, with large employers, not naming any of them, but that was always a great secret that you could roll that money over. But and they used it for key executives and key position people, but the people, the ordinary employees never heard about it. It's coming out now, and it's becoming more public now, where people will be doing this.
Absolutely. You know, we don't see this with physicians a lot, but where we see it is if you do want to start to use your retired money and you're retired early and you want to avoid the 10% penalty, there's a rule called 72T. This allows you to start taking money out prior to age 59 and a half out of a retirement plan or IRA. You have to do it for 5 years at a 59 and a half, whichever is longer. And there's a couple different formulas. You have to choose one of them, but this is purely designed to create an income stream off of your 401k or IRA prior to 59 and a half. Don't see it happen too often, but we just want to point it out that there is,
especially with physicians, you almost never see it.
Yeah, that's true. RMDs, they force you to start taking money out of your retirement plans, everything other than Roth, really. At age 7, April 1st of the year you turn after you turn 72. How this is calculated is they take all the prior year's ending balances, and there's a divisor, and that calculates your RMD. It usually comes in around like 3.7 in the first year, and then it goes up every year based on your age. Mike, you want to talk about the penalty on this?
The older you get, the higher that percentage that you must take out is, because the government wants their money. They want the taxes. So they force it to you. The older you are, the more you have to take out. And if you miss it, you're going to have a big penalty problem. It's 50% of the amount you should have taken. That is a huge penalty. They made it a little bit simpler for us by just changing it last year to 72 instead of 70 and a half. Go ahead, Jeff.
Yeah, one thing I like to point on the RMD as well is if you inherit an IRA from a non-spouse, you have to start taking those distributions as well, and that same 50% penalty applies. So if my grandmother died and left me an IRA account, I moved that into an IRA BD, or beneficiary designated IRA, I have to start taking money out of that as well. So the RMD applies to when I turn 72, but it also applies if I inherit a non-spouse IRA. There's RMDs associated with that as well. And watch out, same 50% penalty applies to that.
Yeah, on an RMD, one of the, I think, a practical thing that can be done and is done very often is people will automatically take that RMD at a certain time of the year. For example, I'll bet you most RMDs are paid out in December of the year for some reason. Then that way they know that's been paid. It's on automatic, and they're not going to be in danger of paying that penalty.
Absolutely. So that wraps up our session for tonight. Next week we've got another great session. It'll be same time, same place. We cover all of it. We cover investments heavily next week, which is all the different indexes, how to develop an asset allocation. We also cover risk management, which is how to protect yourself in the event of death, disability, long-term care. We cover Social Security next week. We usually have a lot of good questions on Social Security. So we've got a really filled session for you next week. If you can't make next week, it is recorded. So the HCMA can email a copy to you, so you can see it if you're not able to make it. And after the second session, you'll get an invitation that if you have questions for us, you can swing by the office or through Zoom. You can set a one-on-one appointment for if you want to get a full financial plan done for free. We've set up a relationship
agreement with HCMA.
Yeah, so because we're a sponsor, we're trying to give back, and we're waiving our plan fee for anyone who's on this call through HCMA. Through this presentation.
Another thing is that when we get into investments, basic investments, and then come up the ladder a bit, we do it in English, where you don't need, 5 MBAs to understand what's going on. You're trained in medicine for the most part. So we explain it very step by step. And I think it's a tremendous help, especially to physicians. Being on the faculty, I know that you guys you men and women had 10,000 hours of training before you walk out the doors to go into practice, and none in finance unless you were in our courses. So we do it in very understandable language. Did we lose Jeff?
Okay.
Oh, there he goes.
Right now, I don't see any other questions. Just good positive feedback on how you make things easy to understand. So I want to thank both of you for your time tonight. We'll look forward to joining you again and all you attendees next week at 6:30 on Tuesday night. And have a good evening.
All right.
Thank you, everyone. Have a good evening.
Okay. Bye-bye.